We're still waiting for any kind of outcome from the 7th Circuit U.S. Court of Appeals in the challenge of Illinois' gun and magazine ban, and in less than 2 weeks, you've got the registry that's set to open with a deadline of January 1st to tell Illinois State Police through a sworn affidavit that you have a banned firearm and whatever attachments they may define or face criminal penalty. And you've got that federal appeals court case still lingering out there. However, you also have in October, attorney Tom Mag, he's got a case back in front of the Southern District challenging the state's gun and magazine ban on vagueness grounds. Will we hear anything about the Fifth Amendment arguments anytime between now and when the registry kicks in January 1st with those criminal penalties? All of that's still uncertain in federal courts, so we'll watch what happens there. But in state court, we thought things were done with the case that State Representative Dan Caulkins took all the way to the Illinois Supreme Court, challenging the state's Protect Illinois Communities Act, the ban on semi-automatic firearms that lawmakers defined as assault weapons. And that case was ultimately decided several weeks ago with the Illinois Supreme Court siding with the states. But did they really say that there's no compelling argument to make in saying that the state's ban on certain weapons is unconstitutional? Well, how that case impacted attorney Tom DeVore's case, you had the lower courts essentially say, hey, the Supreme Court, they said that the Protect Illinois Communities Act is constitutional, so we're vacating your thousands of temporary restraining orders that DeVore had secured months ago and essentially dismissing the case. But attorney Thomas DeVore last week on Thursday, he filed a motion to reconsider, as we heard about when we talked with him shortly after the end of the Supreme Court case here in Illinois. So in state court, it's back alive with a motion to reconsider. Tom DeVore joins us right now. Tom, thanks for taking time with us this morning. Hopefully I set that up properly, but I want you to kind of break down what your argument is, what the Illinois Supreme Court didn't do, and where we're going to go from here. Good morning.
Good morning, Greg. Thank you very much. Yeah, you set it up perfectly. You know, the Caulkins case we've talked about a lot, and the ruling that the Supreme Court issued, you know, I didn't agree with it. I understood it. You know, I mean, we as lawyers many times will read a ruling and go, yeah, I don't think you got it right, but I at least understand where you're coming from, right? And so in the Caulkins case, I understood where they were coming from. You know, Greg, from the day that Dan Caulkins foolishly ran his case to the Supreme Court, I always told you he's going to lose that case more than likely because he didn't have any facts. He can't meet his burden of proof that they're going to require of him to put forth. And that's exactly why he lost. And I've always said that the Attorney General and the governor very cleverly got Dan to foolishly do what he did. And I was right. And so the Supreme Court's ruling was very clear where it says, and it comes right out the gate in their holding, Greg, it says, Dan Caulkins failed to meet his burden of proof. And that's why you lose. The Supreme Court did not say that under no set of facts could a citizen prove or not prove, lack of equal protection. They just said Dan didn't accomplish that. And that was very important. And so when that ruling came down, I don't think there was a lawyer in the state, except, you know, unfortunately, the court that we're sitting in, that said that that forecloses any citizen's ability to argue equal protection. And ironically, the motion to dismiss that was sitting in front of the Effingham County Court by the governor and the attorney general didn't even ask for the case to be dismissed in its totality. It merely said that the three readings clause and maybe the injunction should be dismissed. But the governor or the attorney, none of the state parties asked for the whole case to be dismissed. The judge maybe misunderstood their motion. Maybe he was doing it on his own. Dismissed the case in its totality, saying you can never prove this case because of what the Supreme Court ruled. And we can talk about for a little bit why, in fact, I disagree with the judge, and I think that he committed reversible error on his decision.
And then that's the reason why he filed for a motion to reconsider his ruling on vacating those thousands of temporary restraining orders. Talking with attorney Thomas DeVore. And Tom's, you got, of course, the issue of training and sworn affidavits that you've compiled here, and ultimately just asking the judge to say, hey, reread the Supreme Court's ruling here. In the state Supreme Court, they didn't, summarily dismiss this, saying that nobody could prove this. They just said Caulkins couldn't prove it, and you're saying you can prove it. We've heard some of this before, Tom, but just kind of break down how you feel you're going to be able to prove this.
Absolutely, I can prove it, Greg. And keep in mind, I don't like to start talking about conversations and conjecture, because courtrooms are not about conjecture. But I know unequivocally that the training argument made by the state was something that they made up the day of the hearing for the TRO that I had back in January. When we filed this case for equal protection in the state court, the governor, attorney general, or none of the legislative defendants saw that coming. They thought this was purely going to be a Second Amendment argument. They never saw a state equal protection. So when we filed that, they had to come up with the reason of why they exempt these categories out. And they chose training because they had less than 24 hours to create an argument against our equal protection claim. I know that to be true. I can't create conjecture. I have to prove it with facts.
But Tom, is there anything in the law that spells that out, that these exempt classes, being law enforcement, retired law enforcement, security, industry individuals, people who work at jails and wardens and prison guards, they're exempt from the ban, meaning they can go and buy semi-automatic firearms and have those without having to register. So was there anything in the law that spelled out these exempt individuals are exempt because they get X amount of hours of training on these types of firearms?
No, not only is it not in the statute, more importantly, Gregory, it's not in the record of the legislative debate, because there wasn't any. It's not in there anywhere. And that's one of the threshold issues that, again, with all due respect to the attorneys in that case, Caulkins failed to prove. When the Supreme Court says, Greg, this is very important for people, and people will get this even if they're not lawyers. When you have to prove, in order to say that this law violates equal protection, that you as a citizen are equally and similarly situated, that's the language, you're similarly situated to the exempt categories. You're with me, right? The threshold issue that you first have to establish is, where do the exempt class stand? Because I can only show that I'm situated similarly to them if we know where they're at. And so this whole issue of training, that was complete conjecture by the attorney general and the governor and the legislative descendants. When they argued training in our case, they lost. When they argued training in front of the Supreme Court, it was all conjecture. There was no baseline to say this is their training and this is why they are sitting in a superior position to the citizen. There is nothing to support that. It was all conjecture, but the Supreme Court bought it. If you read the Supreme Court's ruling, they talk about some of the training of the law enforcement. Now, keep in mind, it's not mandatory in the law enforcement world. If you look at the actual records of law enforcement, I just don't have them in the case yet. Many, many, many overwhelming law enforcement officers have no training on these banned weapons whatsoever. They're trained in handguns and shotguns. But the Supreme Court, when it gets to all these other enumerated classes, because there's 7 enumerated classes in the statute, they don't talk about the training that these persons have in these banned weapons, because they don't even hear that from anybody. The governor very cleverly, because again, Caulkins was a fool, with all due respect, took him to the Supreme Court with all the conjecture. It's about training. It's not in the statute. It's not in the legislative minutes. But if you, again, they didn't want any discovery. You know how hard they're fighting our case in discovery, because they know I'm going to prove, when it comes down to it, that the citizens of this state are similarly situated, regardless of whether you're a retired Navy SEAL, as some of the stuff you saw, or regardless of whether you even have conceal and carry training. Really is not relevant, because you're dealing with banned weapons. Having training on a handgun for a 4-inch Glock 9mm, what's it got to do with an AR-15 platform? Nothing. That's why I've attached the affidavit from the FOIA request that Kirk Allen did. It's a critical piece of information that shows that the prison wardens, which is one exempt class, I could really stop with them. They don't have any training at all on these weapons. And if you read those records and you understand training of firearms like I do, I'm a certified training instructor. These folks that are getting this training in these handguns, these prison wardens, aren't even astute with weapons because they're slapping the trigger all the time, which means they don't even know what they're doing. They don't have any training, Greg. This whole training argument is a fiction, and I can prove it.
Tom, we've got less than a minute here. What's next? What's the timeline look like? You got a hearing coming up, possibly, and if so, could that possibly lead to a preliminary injunction of sorts, or what do we see happening here in the next few months?
Governor's got 30 days to respond from the 14th. So October 14th, they have to respond to our motion to reconsider. We've then got 21 days to file a reply. That'll put us beginning in November. We'll have a hearing in November on the motion to reconsider, I suspect. We will be asking the judge to reinstate the case and then leave the temporary restraining order in place because we can prove likelihood of success on this case. We've attached the documents that definitively prove it, Greg, that there's no training for a lot of these people. And so in November, we'll have a hearing. If we don't win there, we're going to the appellate court, we're going to the Supreme Court on both issues, not only the equal protection, but on the 3 readings rule, the procedural violation, because the Supreme Court, at least 2 justices said that's the threshold issue, and we're going to push that too.
We'll be watching this closely. Tom DeVore, attorney, of course, with the case to be reconsidered after he filed that motion last week. We'll definitely connect again and keep updated on this case.
Thank you, Greg.
It is Springfield's Morning News on 92.7 WMAY. Springfield's News and Talk, 654 from Culver's West on Wabash.
Culver's West on Wabash.